whether it be breach of a real estate contract, employment agreement, or other civil dispute, it comes to my attention that the vast majority revolve around a contract. And frequently, the first order of business is to determine, is there a contract? Is the contract valid, and what are your damages? In our lives, we all make promises, and our ethical and moral values dictate whether they're kept or not. The only difference between a promise and a contract is a promise that's enforceable. It's a contract that you can go to a civil court and get relief if the terms are breached. What are the elements of a contract? Frequently you hear the terms meeting of the minds, mutual assent, all of which revolve around the simple offer and acceptance. To have an enforceable promise, it must be an offer that is specific with regard to the terms, the duration, the subject matter, time for performance, and an acceptance. Someone accepts the terms. Once an offer and acceptance of a contract that is enforceable are made, the contract is formed. There are other elements to be enforceable that must be met. There must be consideration. You have to give something or give up something, except for a very rare number of situations. They must be legal. You cannot have a contract to shoot somebody. If the subject matter is not legal under federal or state law, regardless of how mutually assenting you are to the terms, they're not enforceable in a court of law, such as a gambling wager or other contracts against public policy. There must be an execution of the agreement if it's in writing, and it must be accepted according to the terms of its offer. If it says by 3 o'clock on Wednesday in writing, hand delivered to this office, that's the way it has to be done. If it's open-ended and you put it in the mail, you probably have a contract, whether it's rejected before that mail receives the other party or not. But in any event, the basic principles of the contract then give rise to what are the remaining terms of the contract, which are usually the elements of litigation. The time for performance, the obligations of the parties, the duties of the parties. If the contract terms and duties are not met, you have breach. Now, a simple breach may not give rise to an cause of action or damages if it's not material. It must be a core item that violates the terms of the contract and creates damage. Frequently, you're required to tender your performance before the other party is in breach, depending on the type of contract it is. It is astounding to me how clients are willing to pay tens of thousands of hundreds of thousands of dollars in attorney's fees for material breaches of large contracts without blinking, but they rarely put any money initially into the contract to settle the lawsuit before it's filed. Preventive legal care with this regard could be very beneficial. Spending a little bit of money to make sure you have a binding contract. So issues such as confidential information, any competition, proprietary information, venue, choice of law, waiver of jury trial, and in today's world we live, arbitration clauses, if agreed to before the contract signed, and if those provisions are in the contract, you can limit by 50% your cost of litigation to enforce a contract before you ever sign it, for very little in attorney's fees relative to the expense of significant litigation in state or federal court.
Nacol Law Firm, may I help you?